Good evening, guys. It's Ozzy with the Columbia Basin Home Group, and I'm back again for our Monday segments, real estate tips. All right, so today, contingencies. What are they? What are my rights as a buyer or as a seller? I'm going to go over the what's, the hows, as far as a real estate contingency. So what is a contingency? So first and foremost, in a real estate transaction, a contingency is pretty much A is going to happen if B happens. So in the case of a real estate transaction, I will buy your home under the contingency that I sell my home. I will buy your home under the contingency that I get funded and financed by XY lender. I will get your loan under the contingency that title is clean, under the contingency that the home is insurable, what have you. So pretty much there's a whole list of contingencies that have to be met before the closing period, and at which point these contingencies will either be waived, satisfied, or pretty much it's anyone's guess for the most part, but for the most part they are satisfied or their timeline lapses, so at which point they're considered waived. Now, as far as your contingencies go, now the reason why you give your earnest money up front is in the event of a contingency default. So a lot of times the earnest money deposit will be held by the title company as a collateral for if the buyer decides to get cold feet last minute and he defaults without any contingencies or any good reason for doing that, and at which point the transaction would go into arbitration, and then at which point buyer and seller would pretty much see who's liable and who is who the earnest money gets released to, or pretty much meet in the middle. It can go either way. So a lot of times the earnest money deposit, it's a safety net for the seller in the event that the buyer defaults. Now, as far as your timelines go, now every real estate contract is a little bit different, granted. So your title contingency is not going to have the same timeline as your inspection contingency, as your finance contingency. So the standard boilerplate language in the Washington State real estate contracts is for a title contingency. You will have 5 business days after the preliminary title receipt from the title company, then at which point you'll go through the title and make sure that it's clean, that there are no judgments on it or what have you. Another one, the finance contingency. Now for that one, the timeline may be a little bit differently because it might take you some time for it to go through the appraisal process or for it to go through final underwriting or what have you. So a lot of times a finance contingency may be a little bit longer, maybe 21 days, maybe 30 days. If it's an FHA loan, then heck, maybe 40 days. And of course, you know, depending on what is on the fillable parts of the contract. So a lot of times the timelines can differ depending if you want to be more aggressive. For instance, I can choose to automatically waive my finance contingency in, let's say, 20 days. And after those 20 days, if I haven't waived it or I haven't terminated the contract based on non-performance of loan, then at which point I will deem the contingency waived and I'll agree to move forward. And if I don't, then I would lose my earnest money. Now, satisfying a contingency, it's pretty much once buyer and seller, in the event of an inspection or what have you, have agreed upon certain items. If it's from an appraisal standpoint, maybe they've agreed on price and buyer is willing to pay X amount in difference from appraisal price or what have you. But it's pretty much the point in the contract where the certain contingency is deemed satisfied and all parties can agree to move forward upon closing as described in the contract. And finally, waiving your contingency. So a lot of times waiving your contingency, I will ask which contingency is it, of course. If it's your finance contingency, does your lender feel confident that it'll close? Has the appraisal came in And can they waive the appraisal? Is there enough funds to close? So a lot of times it all depends on how aggressive you want to be. If you want to choose to waive your inspection contingency, by all means, if you feel comfortable doing that, that is also an option as well. And essentially when you waive your contingency, you're pretty much foregoing your rights on that contingency, and you're just going to move forward regardless of that condition. You know, for instance, if it's an appraisal, then if it comes in low, then you'd be responsible for the difference. If it's financing, if you waive your finance contingency and at the end the lender doesn't pull through, then at which point your earnest money would be in jeopardy. And moving forward, defaulting. So when you default on your contingency, it pretty much means that you failed to perform in the allotted time, and at which point your earnest money can be in jeopardy. A lot of times it's at the discretion of the arbitration committee, and yeah, so it can go any way. So a lot of factors would be taken into consideration, but for the most part, guys, just following those timelines, staying on those timelines, making sure your agent is on top of it, and making sure your agent knows his legal contracts, because that could be detrimental towards you, towards your bottom line, and towards your buying or your selling of your house. So if you do have any more questions, by all means, don't hesitate to reach out. If they're more broker oriented questions, then I'm happy to ask my broker and I'll get back to you guys if I don't have the answer. But with that said, guys, I hope you guys enjoy this week, and I'll see you guys next week.